My name is Rob Leverett. I'm chairman. This is the Subcommittee of Rules on Lawsuit Reform, and we're going to start our meeting here in 1 second. We've got one member not here yet, but I think he's on his way. If there are any members of the House in the room who would like a place to sit, there are some seats up front. If you want to come move up front and sit in some of the chairs, that's fine. I'm going to go ahead and, before we get started here, just recognize Chairman Newton to give us a word of thanks.
And pray with me. Father, you promised to give wisdom to those who ask. We're asking for your wisdom today as we deliberate important matters for Georgians. Help us to hear you and to act accordingly. Thank you for this time together. In Jesus' name, amen.
Thank you, Chairman Newton. Ladies and gentlemen, so we've, for those of you who haven't been with us, we've had a few days of meetings already. I think someone said 12 hours or some number of testimony. So I think we've heard the testimony we want to hear. Senator Kennedy, the sponsor of the bill, has sat here with us during each of these meetings, and I have asked him to wait until the end here to sort of give his final comments on the bill. So I'm going to recognize him now to come speak to the bill, and then I've got a substitute I want to put before the committee, and we may have some amendments to be made on that too. But Senator Kennedy, if you'll go ahead and get us started.
Mr. Chairman and members of the committee, good afternoon. Thank you for allowing me to have joined you for all of these hearings that you've had and for the time that you've given, Mr. Chairman, to the public, to me, to the many questions that have been asked. I say good afternoon to all of you as well as the people who have an interest in this, and I thank you for the opportunity to be here again today.
I figured you didn't have anything else better to do.
Yeah, well, yes, sir. As I told you on day one, my time is yours, and
well,
I think I've proven that, haven't I?
Graciously appreciates the time you've put into this, so you've been very patient.
Yes, sir. Because you have been very patient and heard from a lot of members of the public that have had input on this, and this committee has heard a lot of facts, a lot of testimony, a lot of opinion testimony. I'm not going to hopefully bore the committee with a recitation or reference to all of that, but I want to try to focus our attention on a few things, at least in my remarks, and try to bring, I hope will be some clarity as to what this bill does, and very importantly, what it does not do, as it is stated, as has been stated during the course of these many hours, quite frankly, things that this bill purports to do that it simply does not. I want to highlight the efforts of the committee, the stakeholders, and the interested parties on both sides, because at the end of the day, what we are all here about, those of us that have a vote and those of us that serve in the legislature or in other roles here, is to have a good final product of legislation for the state of Georgia. I want to remind the committee that these efforts began really 2 years ago when the governor's team began researching and holding conversations about this topic and gathering input from a wide variety of stakeholders across the state about what language ought to be in this bill. Well, why? What was one of the reasons that this got brought to a head? Well, it's several things, and this committee has heard about many of those, but I would tell you one of the issues that I think is most telling was one of the final comments that one of the witnesses made about, I don't know exactly how to describe where we are and what got us here. And I think the answer is, to some degree, what describes where we are here is the #1 state on the judicial hellhole list. Now, regardless of who produces that opinion, regardless of what metrics are used to arrive at that number, it's all relative. What we know is we are the worst of all 50 states. That's very telling. That's alarming. That's a wake-up call. So the governor's team started soliciting information from folks from around the state. And before Senate Bill 68 was filed, there were meaningful discussions that were held not only leading up to and what was formed ultimately to be the bill that I dropped as Senate Bill 68, but also those conversations continued. And as the governor stated in his State of the State address, he said that tort reform would be his #1 priority for the 2025 session. But he followed that by saying, I will continue to negotiate in good faith. And he absolutely has done that. And we have seen that because the bill that I presented to the Senate Judiciary Committee was a substitute that had changed several of the provisions of the 9 original provisions dropped, and in fact, one section was completely removed from Senate Bill 68. That removal and all of the changes in Senate Bill 68 that were made were all as an accommodation for concerns that were raised by the plaintiffs' bar or GTLA or folks that basically opposed the concepts of the bill. Well, after the bill passed out of committee, and as it moved on to the floor, and again, in the spirit of compromise, and again, trying to make the bill better, it was amended again after listening to folks whose clients and cases may be affected by the bill. Senate Bill 68 was adopted by the Senate with a substantial revision and came out of the Senate, off the Senate floor, with bipartisan support. As you have referenced, Mr. Chairman, this committee has heard, I think, over 15 hours of testimony and feedback from the public and from various folks. Furthermore, the substitute before you today intends to strike a balance and address concerns for both sides of the issue. The substitute bill that I understand is before you clarifies language throughout the bill, guards against the misapplication of provisions to protect all parties to a case, and further protects the rights of victims to ensure that the vulnerable are protected throughout the course of civil litigation. I want to talk for a minute about some of the testimony that we heard. Again, as I said, this bill and what you have before you, committee, to vote on was not created overnight. Many legislators have been actively working to get tort reform and some measures because of the problems that were known to be growing for many years. The governor announced tort reform, as I said, as his #1 priority, and they've actively worked to craft a solution to balance what is an unbalanced civil justice system. We spent last summer also hearing from businesses at the governor's direction and leadership from big business, small business, healthcare industry, everyday Georgians about the need to balance our civil justice system. And with the culmination of all factors that I mentioned above, I believe that the bill you have before you is a carefully crafted compromise. However, notwithstanding that, this committee has heard testimony over the last few weeks that if Senate Bill 68 is passed, slumlords are going to take over the housing market in Georgia. Georgians will be less safe. Georgians will be discriminated against. Plaintiffs will be unable to sue businesses or insurance companies ever again. Folks, that's not what Senate Bill 68 is about. It's not what it's trying to accomplish. It's not what a plain reading of the bill would inform you of, and it's not what it does. Let me talk about Section 6, Mr. Chairman, on what we've called premises liability and a few responses. I want to start with a testimony this committee heard regarding Section 6. And the problem with our current framework is a lack of framework. And that lack of framework, which in essence produces a lack of predictability, and a lack of predictability equals a lack of stability. And part of that, most of that, stems from the current structure we have, which is not from statutory direction from this body, but rather more of that is found in case law, focuses on one issue, and that is foreseeability. You know, there's always some foreseeability in a criminal activity. However, just because an act is foreseeable does not mean that a business owner has the sole ability to control or stop that activity. And to address this ambiguity that we have in the law, Senate Bill 68 seeks to strike a balance between actual knowledge and constructive knowledge by using both of them in the bill at two different times for the analysis. If you look at lines 227 through 228, and Mr. Chairman, my lines may be a little off. I'm not sure that that includes the sub that was from today. but it's the provisions under section 6. I believe it's 227 and 228, where it imposes constructive knowledge for assessing the risk that has occurred. Right below that, you will find where the portion of the bill talks about the actual knowledge of the prior acts. That's just logical. It's commonsensical. It imposes duties in a way that is fair. It's reasonable to require owners to have actual knowledge of prior acts, which would be established through many different ways: documentation, police reports, formal complaints, however they may be filed or documented. But the bill also allows for constructive knowledge, which of course is a lesser standard than actual knowledge, as it relates to the risk of future harm that may be created. Think about our current premises liability standard as a policy question. If foreseeability is the exclusive standard of negligence, why would any entrepreneur, any investor, anyone that wanted to bring their capital, their resources to Georgia, invest in a high crime area? Well, the answer is they wouldn't. They never would. You know, for example, Atlanta News First reported a story about an affordable housing complex in South Fulton County that is suffering from skyrocketing insurance premiums due to Georgia's vague premises liability laws. This complex has gone to great lengths to try to protect its tenants and trying to protect its investment. And along with employing regular regimens and security guards, the complex installed over 100 cameras, spending $18,000 per month just to monitor the premises. And regardless of these efforts, their commercial insurance costs are roughly up 600% in 2 years. Just like any other cost, guess where that cost is going? It's getting passed on to the consumer. It's getting passed on to the tenants who live there in the form of course, increased rent. Well, let's look at another example. How about an affordable apartment complex on Cleveland Avenue here close to downtown? At this location, the owner has gone so far as employing a robotic security dog to help try and deter crime. When that complex opened a number of years ago, the owners of the complex were paying roughly $50 per unit for insurance coverage. Now, they're spending over $1,500 per unit. Well, don't take it from me. Notwithstanding many of the folks that came and testified before you over the last several days, last month an Atlanta City Councilman representing the city of South Fulton stated that Georgia's current laws are not only hurting businesses, but preventing vital resources such as grocery stores and affordable housing from expanding into his district. The councilman cited the negative effect that lawsuits have had and are having on local grocery stores and their inability to be able to operate because they can't get commercial insurance. Additionally, this committee also over the last several days has received some feedback about the landmark CVS case that I have alluded to, as well as many other folks have alluded to as well. In that CVS v. Carmichael suit, the one that's I think generally referred to as the $42 million verdict, 95% of the blame was apportioned to CVS for an after-hours shooting in their parking lot, with 0% of the fault being assigned and apportioned to the one who had the gun, aimed it at someone, pulled the trigger, and shot him. They were assigned 0% of fault. This is a sad but yet firm reminder of why we have to rebalance and we have to have guardrails in the statutes that we pass so that others know, whether it's juries following the law or businesses that want to make sure they're in compliance, have some stability and predictability going forward. You know, comments were made about the dangerous environment around CVS and how the CVS verdict was justified and how passing the bill would completely disregard the impartial conscience of a jury. I'd like to ask this committee, though, who creates the law? Is it random juries around the state in different venues with different fact patterns and different judges? Is it one Fulton County courtroom jury? Or is it us? Is it us? Do we have that responsibility? Of course we do. I want to point to you and read to you just a couple provisions from Justice McMillan's concurring opinion in the CVS case. And you'll see in these quotes, you'll hear the court struggling in dealing with the very issue that I am describing for you and that which I'm asking us to fix. And at the end, you'll see who the justice says needs to act. Quote, "The majority's attempt to craft a standard that would require the existence of prior, substantially similar crimes before imposing liability has the potential to increase the liability of proprietors, landlords, and property owners for the criminal acts of third parties, and will most certainly result in more cases going to trial with a concomitant burden of attorney's fees and cost and loss of time and other resources in litigation." Further, another quote, "In other words, the way that Georgia courts have interpreted the reasonably foreseeable," close quote, "exception would all but swallow the general rule that a proprietor has no duty to protect invitees from third-party criminal acts, because essentially any circumstance would be sufficient to create a jury issue as to reasonable foreseeability and a proprietor's duty." Another quote, "To what extent and under what circumstances proprietors should be held for third-party criminal acts are decisions best left to legislatures, which can consider the policy and practical implications, especially in high-crime areas, of increasing such liability and the cost of doing business." Close quote. And one more. Let's take another look at a concurrence from Justice LaGrua and Justice McMillan and Justice Colvin joining in this. Quote, "These cases present a challenging issue regarding the scope of a proprietor's liability to invitees when the criminal conduct of a third party causes injuries to said invitees. I write separately because I am concerned about the impact of these laws will have on those who reside in such, quote, high crime areas, close quote, and who could face the harsh and mounting reality that businesses faced with an increased exposure to liability because of the very area in which they have chosen to do business will cease operations or raise their prices to offset the cost of additional security measures. I would urge the General Assembly to consider these issues as they institute laws imposing premises liability on businesses in this state." And finally, the majority opinion itself says, "In rendering our decision, we are mindful of the economic and policy arguments advanced by the parties, but such considerations are reserved to the General Assembly. This court is bound by what the law is and not what the parties or members of this court think it should be." Members of the committee, I believe that the opinions of the highest court in our state highlight the concern that we all should share regarding the pitfalls of our current system if we as a legislature do not act. Let me talk now about Section 6, and specifically as it came to be discussed in the sex trafficking context. This committee heard countless testimony surrounding the evils and tragic circumstances of what are the horrific circumstances that flow from human and sex trafficking. It's been said that the provisions of SB 68 will enable or embolden the act of sex traffickers and the actions of sex traffickers across the state. This tragic testimony from victims is actually why we passed OCGA 51-156 in 2021, which fundamentally mirrors the Federal Trafficking Victims Protection Reauthorization Act, the Federal Act of 2003. Current Georgia law already has a specialized remedy for these horrific acts, and that's why the Senate substitute specifically referenced this code section to make sure that it was clear that nothing about Senate Bill 68 in any way should, would, or could operate to impair the victims of sex trafficking from being able to pursue whatever remedies they chose under Senate Bill 68. Because 51-156 holds those who, quote, knowingly benefit financially or by receiving anything of value, close quote, from sex trafficking. It includes hoteliers who turn a blind eye to this activity on their property. That was, in many respects, at the heart of what we heard from some of the very compelling witness testimony. The bill does not require the hotelier to be a co-conspirator for liability to attach or for there to be a recovery. I believe the bill before you today clearly emphasizes that the intention of SB 68 is not to harbor, enable, or turn a blind eye in any regard to this grotesque activity and conduct. I have to add to this and remind my fellow legislators, and many of you have been here for quite some time, and most all at least for 6 years, that the Governor Kemp and First Lady Marty Kemp have championed protections for sex trafficking victims. Let's take a moment and look at what our First Lady has done during her tenure as First Lady, just in this area alone. She has suggested, or worked to author and pass 9 different bills involving sex trafficking and to stop the horrific behavior of human trafficking. Senate Bill 158, the quote, Anti-Human Trafficking Protection Response Act. Senate Bill 430, that was in 2019. Senate Bill 435 in 2020, the quote, Survivors First Act, close quote. And on and on. House Bill 823 in 2020, House Bill 911 in 2020, Senate Bill 33 in 2021, Senate Bill 34 in 2021, Senate Bill 461 in 22, Senate Bill 42 in 2023, Senate Bill 370 in 2024, and pending this year as she continues to fight for people that are the victims that we're talking about in this particular section, Senate Bill 42. As Marty Kemp, our First Lady, continues to fight for this. So yes, it does cause one to bristle when there's been suggestion from people that somehow a bill authored by Governor Brian Kemp, who is married to Marty Kemp, would suggest or certainly offer or put his name on a bill that would do anything to reduce the recovery and remedies available to sex traffic victims and human traffic victims. But don't take my word for it. I want to read to you a filing submitted to the United States District Court for the Northern District of Georgia that came across my desk. This filing signed by a member of the bar. And of course, there are obligations on us bar members when we sign a pleading to make sure that it meets minimal requirements for candor and truthfulness. Quote, fortunately, Georgia has followed the federal government's lead in recognizing that actors other than the actual traffickers and Johns were participating in, promoting, facilitating, and benefiting from the selling of sex and sex trafficking through the passing of Senate Bill 33. With the passage of Senate Bill 33, now codified as OCGA 51-156, Georgia now joins those states in providing trafficking victims the option to pursue civil suits. Again, those are not my words. That is a quote from a complaint in a lawsuit filed in federal court authored by one of the members of this very subcommittee. While this case is ongoing, the complaint says it better than really I ever could. Georgia has strong protections for trafficking victims, and it allows them to recover for their injuries and to punish the bad actors involved. Senate Bill 68 does nothing to limit that recovery. Additionally, the substitute bill further addresses any concerns in this area. I also want to address the argument regarding the definition of, quote, negligent security, as has been argued or suggested to encompass claims against employees or agents, such as those that we heard about from the case against the YMCA. I want to be clear, this bill does not preclude or prohibit any of those claims filed by the presenter who testified very sympathetically, very passionately, and very understandingly before this committee. But that witness, that presenter, successfully brought claims regarding and under counts of federal sex crimes, state negligent hiring, state failure to warn, state negligent security, and punitive damages. Out of all of these claims, only one of those causes of action was addressed in the bill, and that is, of course, the negligent security one. Further, we talked about nuisance, and we heard about some discussions of that, and the lawyers spoke about it as well. With regard to the nuisance claim argument brought up in the testimonies, negligent security does not preclude nuisance claims. Nuisance claims, however, are not designed to remedy personal injury claims. In bringing a personal injury claim, such as a nuisance claim, is just repackaging a personal injury claim by a different name. That's why lines 181 includes nuisance claims, not to block true nuisance claims, but to ensure that attorneys cannot creatively plead their way around the standards within Senate Bill 68. I get it. We've been here a long time talking about a multi-page bill that's got 8 sections. It's complex. But what we have done is an attempt to codify a body of law and introduce a workable framework to provide stability to businesses and consumers while ensuring fair compensation to those that have been wronged. The notion that restaurants and housing providers and other businesses will simply somehow stop providing security if SB 68 is passed is off base or really more absurd. The vast majority of businesses have to operate well to stay in business, and they are protecting their customers and their employees. But what they're also asking for is clear and reliable standards in order to serve their communities and their businesses and their patrons and their customers without the threat of lawsuits being filed for actions of a third party that are largely beyond their control. Mr. Chairman, I want to move now to Section 7 of the bill and talk a little bit about phantom damages. I believe it's originally on line 363. Section 7 addresses truth in medical damages, providing transparency to jurors in evaluating their damages. Section 7 was amended in the Senate from what was originally dropped as the governor's bill so that the jury can now see both numbers. And the basic argument was the plaintiffs were saying, wait a minute, the jury ought to only see the rack rate, the retail rate of the hospital, even though it may be a multiple of what the actual reimbursement amount needed to go to the plaintiff is. Of course, those that are seeking some relief were saying, wait a minute, shouldn't it be the actual number? We're talking about a concept of reimbursement. What needs to be paid to the plaintiff so that they are reimbursed? It's part of the special damages analysis that we've talked about. They need to get and should be paid every dollar if liability attaches, every dollar necessary to make them whole, but not a dollar more than that. What you see here is a compromise again that says, let both numbers go to the jury. And then it's up to the lawyers to, with their process, both sides, let them try to convince the jury which is the correct number. There were some suggestions of misinformed or misguided witnesses that even wanted to talk about this is going to limit the amount of damages. But nothing in the bill is a cap on the medical damages or a restriction on what the plaintiff can recover. Section 7 allows the jury to see the, quote, rack rate as we've talked about. But again, I want to remind you, nothing about the analysis of what we're talking about at all touches upon the non-economic damages. That is the pain and suffering. None of that is addressed, confined, modified, or touched by this bill. We also heard testimony depicting how 68 provides an unfair benefit to those without insurance and that a defendant would somehow get some sort of undue windfall. And we heard, we heard arguments that strained common sense, even made by some of the lawyers, as to say, well, it's okay for them to be paid more than they actually ought to be paid because, well, they've got to pay a lawyer. They're not being made whole because of attorney's fees. That's an entirely different issue. That's dealt with in other areas of the code. But I do want to raise a few points. I want to remind the committee that the purpose of special damages, as I said, is because they are specific, because they are calculable to a particular amount, they are there to address what ought to be the correct reimbursement amount. Second, just like all of us, I suppose, when I purchased my insurance, I did so that in the event that I had a medical issue, I would be protected from the financial burden that may produce on me, and it would, at a minimum, hopefully at least reduce that obligation. So why are we all of a sudden pretending as though a person, any of us whom that may be, purchased insurance is getting no benefit for what they paid for until a lawsuit occurs? That just doesn't make sense, does it? Well, of course not. Because we acquire or procure that insurance and we enjoy and expect the protection that it provides during the course of that policy. But regardless of any benefits conferred by the presence of insurance or lack of insurance, is it not reasonable for the jury to have both amounts so that they get a full picture and can make a proper assessment? Ultimately, the provisions of Section 7 allows the jury to consider all of the relevant evidence. We trust our verdicts, so why is there so much opposition to simply telling the jury the truth about the evidence? It seems to me it makes all the sense in the world. They ought to have all of that. And then, Mr. Chairman, Section 8, the last section of the bill involving bifurcation. Some of the claims that have been made about trial bifurcation, I want to remind everyone that, bifurcation has always been in there, but it's been optional. It's not been one that the parties could elect to employ and ask that, in fact, the case be tried by bifurcation. This provision simply, that's in Section 8 of Senate Bill 68, gives an option to attorneys in specific situations. In a medical malpractice case for wrongful death, for example, a defense lawyer might want to bifurcate the trial because the liability portion is complex and almost entirely based on the testimony of experts and medical practitioners, and testimony from the members of the deceased family is unnecessary to prove the liability section. But many have shared concerns about the victims testifying multiple times in a bifurcated trial. And generally, it would be unlikely for lawyers on either side to want to press a victim of a traumatic injury multiple times. Regardless, the substitute that I understand that's before you today addresses this issue by allowing some discretion in this regard. And by the way, this is not a groundbreaking concept, this idea of bifurcation in civil procedure. North Carolina currently bifurcates any case with alleged damages over $150,000. This reasonable change is not crazy or as out of sorts as some folks have come before you and suggested. And then I want to address, there were some comments about this Florida insurance report, and I want to briefly talk about what's happening in Florida. So the testimony provided did a great job highlighting the stark differences between Georgia and Florida and how a headline from a Miami Herald is being incorrectly interpreted. There are key differences between Florida's insurance market and our insurance market that have been lost in the name of the claim of fraud. First, the investigation, as stated by the Florida speaker, is about domestic insurers in Florida writing homeowners policies. These are not the type of policies that the businesses in Georgia are begging for a fair opportunity to defend themselves from frivolous claims. But there's another reason that we should not give credence to the notion that the insurance companies that have provided the information upon which we have relied is somehow part of a problem or that they are lying about it? And the answer is House Bill 1114. The reason that I'm confident that the insurance companies are not lying about the scope of the problem is the legislation that we all passed last year. House Bill 1114 focused on the claims level data. Claims level data. That's not how Florida did their analysis. But we did it here by focusing on the claims level data collected by John King's office, or the Office of Insurance Commissioner, through their examination process. And House Bill 111 collected data independently, and that data was then analyzed independently. House Bill 114 has the accountability measures built into it, including detailing this legislation's effect in future rate filings. The governor's office made sure that accountability and independently verifiable data was present before we started this process. I know many that were looking for and hoping for some tort reform in 2024 were a bit disappointed that this was going to be postponed for a year. But the wisdom and value of that, I think, is seen in the governor's very thoughtful approach in authoring House Bill 1114 that then allowed for the data to be collected so that it informed the bill that you have before you now for consideration. That effort, along with numerous negotiations, ultimately concludes in where we are here. I'm just about done, Mr. Chairman. I want to mention something about how there's been a reference to insurance companies, and in discussing it, we seem to have lost sight of the fact that insurance companies in some respects are like many other businesses. Some would say it's like any other business. You have your cost inputs, you have the revenue that's derived from the sale of whatever the product is, and then you have a resulting profit. But for those cost inputs, what is beyond question is that the overall litigation costs are rising, that the frequency of litigation is increasing, and that the competition in the insurance marketplace is fleeting. The cost of litigation is just like any other cost for a business. It's ultimately passed on to the customer. And the last thing, I'll share a little story. When I first started working on 1114, which was the governor's bill, and I carried it last year, in a conversation I had with John King about how his office oversees the insurance companies and the insurance market in Georgia. And of course, I won't go into all that. That's very specific and beyond what's necessary for here, and we don't have the time for it anyway. But I asked Commissioner King about businesses coming into Georgia, those that want to be here, those that are leaving, those that want to leave, those that are reducing the amount of their business exposure here, those that are making decisions to not renew policies, those that are putting more exclusions into their policies. But specifically as to new companies that would come to Georgia, I asked the question, what do those metrics look like? And the one he said to me that really caught my ear and puzzled me at first was this. He said, well, one of the things we look at is to make sure that they're not pricing their products too low. So, well, Commissioner, why would we care that they're pricing their products too low? I mean, Georgians get a cheaper insurance premium, right? He said, yeah, but we want insurance companies to be financially healthy and here for the long haul so they are able to pay the claims. And if a company comes into Georgia, underprices their product, and then can't sustain the payments of legitimate claims that are made, that ain't good for Georgians, is it? I said, no, sir, it's not. Just hadn't quite thought of it in that exact way. Mr. Chairman, Georgians from all across the state have come to us asking for some reform. We've heard testimony from hospitals, business owners, truck drivers, people that work in those industries, attorneys and more that just want to run their business. They want to provide for their families. They want to live their lives without the unnecessary worry of losing everything that they've worked for because of an unfair treatment in the civil justice system. This bill has worked its way through the legislative process, and as it continues to do that, I would encourage this committee to not forget about the hundreds and hundreds of faces and people who came, each with their own story and their background, who stood on the steps here inside the Capitol when this bill was announced. They weren't here for politics. They weren't here for greed. They were just here for some relief. They were here because they were asking you and me for the vital and urgent support that they sent us into this building to provide. We owe each of them a duty to act. I would ask for your favorable consideration. Our governor, our lieutenant governor, our speaker have all been very clear since the bill was introduced. Our aim is to craft a bill to provide relief while preserving the opportunity for plaintiffs to have their full day in court. If you carefully consider the language of SB 68 and go through the exercise of applying it to the actual language of this bill, not just cherry picking words and trying to get wrapped around the axle with things that aren't found in the bill, it's my hope that this committee will see this bill simply for what it is. It's a thoughtful approach intended to balance our civil justice system. You've heard the testimony, and I hope one theme has shined through, that the fact patterns of the events presented to this committee meet the standard to try a case under our current law. And I want to assure the members of this committee that under the provisions of Senate Bill 68, these cases, of course, can be brought, they'll be heard, and those that have been wronged will be fairly compensated. Mr. Chairman, I think I'll stop there, and I'm at your, subject to your direction. That concludes my presentation.
Thank you. All right, I've got some lights blinking. Concern I have is we've got about 30 minutes and we're going to get kicked out of here, and I've got a sub I want to go through and some amendments we need to consider. So can we keep the questions very short? Okay. All right, Representative Evans.
Thank you, Mr. Chairman. Thank you, Senator Pro Tem, for the 40 minutes of commentary today. I have just two questions, very short. The first one is a two-part question. Yes or no, some of the data that you were referring to from the insurance industry that you said verified the concerns, was part of that the King report from Commissioner King?
Yes.
Okay.
Some from the King report and some from others that we spoke with at the Office of the Insurance Commissioner, yes.
And are you aware that the first page of that report says the contractor who prepared it did not independently verify the insurer's data and did not perform any verification procedures to determine the completeness of the data provided by the insurers? Therefore, the contractor makes no representations regarding the accuracy and integrity of the data and information submitted by the insurers.
I would expect that language to be there. If you think about the model, what was unique and the reason we had to pass H. Bill 1114 in the first place was that we were seeking data and information from insurance companies that is not readily available or publicly available, and that which they thought was proprietary and private to them. So the contractor who sought the information and got it from the various sources, there's no way to back check that.
There's no concern that we couldn't check what we were being told and we just accepted it at face value?
Well, first of all, the model is set so that they were getting proprietary information. There's not yet another source behind that to go to. We were getting the proprietary information, number one. Number two, if you have some reason to mistrust it, this would be the first I've heard of that. Of all the time we've spent thinking about this bill and all the questions you've asked about the Office of Insurance Commissioner, you've never suggested that to be the case. So this would be an entirely new area of concern that I'm hearing for the first time from you or anybody else.
Well, in fairness, it's been a concern I've had for a while, and my ability to ask you questions has been truncated. My last question is, you mentioned in your closing comments there that the business community came here and they stood on the stairs with Governor Kemp, not in greed. I want to make sure you didn't mean to suggest that any of the probably hundreds at this point of victims that have come here to share their stories, you're not meaning to suggest to this committee that those victims were here for greed, were you?
What I'm suggesting is just what I stated, which is to address the issue that many have suggested that this is all about insurance company greed or big business greed or Georgia business greed, and that's not why they came here. They came here because their businesses are closing. They can't afford the insurance premium. They can't get doctors into the state. We heard doctors come testify to that. So that's what I'm talking about, is to address, I think, a misplaced narrative. I'll be kind and call it a very misplaced narrative by some in suggesting that's what's going on and that's what's driving the Senate Bill 68.
Well, you understand that certain people have accused the victims of that too, and I just want you to state on the record here, you do not believe that the victims were here in greed, do you, Senator?
I don't think they were. Do I think they came to testify in greed? No,
Yes.
I don't think the victims came to testify in greed.
Thank you.
No, in fact, I think most of them had already had their case in court.
Exactly. They have nothing to gain or lose from this, like many of the business community and insurance witnesses that we heard. Thank you.
Well, no, that's not a fair way to end that, because, again, the reason I made that statement is because of the false narrative that's being put out there that some of the businesses are here just for greed. That's not the case. It's about the existence of being able to maintain a business, and it's about folks, hardworking Georgians that are trying to make ends meet.
Thank you. Representative Miller?
Thank you, Mr. Chairman. Thank you, Mr. Senator Pro Tem. I did have a question about the negligent security portion of the bill. You described the underlying concept of pinning down what would be reasonably foreseeable for a business, and that is what you are endeavoring to do as it relates to third-party criminal acts in the way that this language is drafted. Do I have you correct?
That's not all of it, but yes, that's.
I'm just talking about that part.
Yes, that part, yes.
Okay.
I think that's fair, yes.
And then, so I guess my question is, once you, and I'm not going to get into all of the layers of what would make something reasonably foreseeable, but let's say a property owner has specific information that there is a serial rapist hitting apartment complexes, you know, coming down the street that particular hotel or apartment complex is on. And let's say, for example, that serial rapist hits the owner's apartment complex and assaults one of the residents. Would there still be a requirement, despite that very specific knowledge, just go with me with this hypothetical, that the crime be the result of a physical condition? So is it knowledge down to the owner has to know it, down to the identity, the time, and the place that the crime could happen, and there has to be a physical condition that is the reason why the crime happened?
Madam Representative, I think we started analyzing, at least what I heard was sort of one portion of the bill, and you have brought in other portions of the bill into that discussion and that analysis, and quite frankly, I don't think I can answer that question.
Let me phrase
in
it
this,
better.
In this context, unless we walk through the whole bill.
Let me phrase it better. So the idea is that the landowner has to be on notice, or the crime has to be foreseeable, correct?
You're speaking of current law or as proposed?
Both.
Well, as I've said, and I think as we agree, the crux of how the cases are being focused on now, the guardrails, is foreseeability.
I understand.
Yes.
But
Okay.
also in your bill, you attempt to define and tailor what would be considered foreseeable for an owner. Is that true?
In part, yes.
Okay.
If you can direct me to a line, I'm happy to look at it if that's...
Sure. I'm referring to, let's see if I have I don't know if it'll be yours, if your lines are the same as the sub we just got. My sub does not have numbers on it. Okay, let's go here. If we start at 224, we start talking about what is reasonable, foreseeable. Do you see that?
Yeah, let me get, excuse me.
It's subsection 1.
You said 224?
Yes, in the sub.
Okay.
Okay. And do you see where there's a discussion about what is defined as reasonably foreseeable for the owner or occupier?
I'm sorry, I'm trying to, these are new line designations for me, and I'm trying to look at my materials and correlate that to 24.
Do you have the new sub?
I think I do. Mr. Chairman, is it 492355S?
Yes.
Is that the sub? Okay.
Yes. Representative Miller, do you
I
have?
have that.
I do have the sub.
Okay.
Yeah. I'm sorry, my working notes are, what I've worked with.
So it's line 224,
Yes,
for
on
you.
the sub, page
Page
10.
10.
Yes, sir. Find it for me.
Mr. Chairman, can you tell me if this section was changed? Right.
There are some changes in the sub.
Does it apply to this section?
It would apply to this section.
Okay.
It was, but the physical condition paragraph is 3, and that there were no changes in that paragraph. Paragraph B is where there were some changes made. And I gather the lady's question goes primarily to the presence of a physical condition.
Yes, sir. In addition to, so I'm trying to understand if the owner or occupier manages to have the level of mens rea or knowledge that you have detailed in lines 224 through, I guess it goes to 240, and if the crime happens, they know all the things that you list out that they should know. Let's assume that is true. Okay, they have the knowledge.
I'm sorry, can you say that again?
Assume the knowledge is there. It can be met. Assume that the knowledge that you have laid out, the standards that you have laid out, that would satisfy reasonable foreseeability for the owner. Assume that is met.
Okay.
Crime happens. Would the injured victim still have to show, in addition to the fact that the owner had the knowledge, that the incident was a result of someone exploiting a specific physical condition?
I'm looking for that physical condition language within this. Can you point me to that
Yes,
line?
sir.
That may speed things up. I'm
Yes,
sorry.
sir. It's line 242. Starts at line 241 of the sub.
So I think the answer to the question is section 51.351, which begins with paragraph paren 1 and goes through 5. Those are all conditions.
And, right?
Because of and that's found at the end of paragraph 4.
So, if someone is, if the owner has this high level of knowledge as is detailed in the sub, and the incident that they have that knowledge occurs on the property, but it doesn't happen as a result of a physical condition, whatever that may be, the owner, occupier, could not be held responsible despite their knowledge?
Well, if what you're saying, and I think I know what your question is, if we're going to base this, when you talk about knowledge, then you're circling back to the fundamental of foreseeability. And if we're going to say that that is the only requirement, no. We are trying to put additional parameters and guardrails on when someone is responsible or legally liable for negligent security. And if it's foreseeability alone, that's not enough. It requires these additional provisions.
Thank you. One more question, Mr. Chairman.
Let's do it quickly because I'm running out of time.
Real quick, staying on the same topic. So when you say physical condition, is it the presence of a physical condition or the absence of a physical condition?
Well, it's not me saying physical condition.
I'm talking about your bill.
referencing. Right.
Right. So when you say in lines 241 to 242, exploiting a specific physical condition of the premises. Is it a physical condition that exists or a physical condition that doesn't exist? So for example, if it exists, it's a broken gate. If it doesn't exist, it's no gate. I'm trying to understand if
I don't think it's, I'm sorry, didn't mean to interrupt you.
No.
I don't think it's limited to, and I know that's been part of the discussion topic of a specific, like a broken lock, some issue like that. But I think we're looking at it too narrowly in that regard, because it's not just one specific item. It can be looking at the circumstances that create the physical condition that the plaintiff is alleging.
Can you give me an example of a physical condition that you have in your mind?
That would depend on the circumstances. I mean, that would depend upon the location, that would depend upon what's there, depend upon what's not there, it would depend upon the surrounding area, it would depend upon the people that are there. Excuse me. So I want to try to answer your question, but I don't want to play games and trying to start mentioning things that is based on some hypothetical in my head that's different from what you would have.
Thank you. Mr. Chairman, I will respect the chairman's desire, even though I have more questions. Thank you.
The chair greatly appreciates the lady's anticipation of the chair's wishes. All right, I got 2 more questions. Chairman Newton, I think.
Thank you, Mr. Chairman. I'll try to be brief. I appreciate your explanation of collateral source, or just trying to get the truth to the juries. One of the most eloquent letters we've gotten obviously lots of emails about this, hundreds for, hundreds against, or dozens against. One of the most best arguments was something like in collateral source, we should allow information about liens, and I know it talks about letters of protection. And then the second thing was what do we use as evidence of what a average reimbursement or a fair price was? And just to read off of that, 2 things. One, on liens, I think 2 years ago we prohibited a healthcare provider to file a lien unless they've already filed the insurance and been turned down. And most healthcare providers do take health insurance. I know another opponent of the bill has called them bad actors if those that just establish an entity just to take personal injury cases and come up with a whole new price list. But the specific that was asked in this defense attorney's who opposes the law, he said we should have evidence of average reimbursement rate accepted by a medical provider for full reimbursement in non-litigation cases. Isn't that really what we're trying to get to with the jury? There's a list price number, and then there's the amount to fully reimburse and get a paid in full stamped on a bill.
Yes, sir. That's exactly what it is. Because again, going back to the thought flow is, it's an item of special damages, which is specific, for which if there's liability, we want to reimburse fully the plaintiff. And so they get every dollar of that reimbursement, not a dollar more, not a dollar less. And so that amount in your example, yes, would be that which was necessary to pay for the insurance company to pay, or whomever the payor was, to pay the medical provider. Exactly, it would be those 2 weeks. It wouldn't be 3 months. Yes.
Thank you for letting the jury know both numbers. I think your compromise was a good one, to let them know that list price, but also to let them know the amount to get paid in full. I think that was a good.
Yes, sir.
Thank you, Chairman. Representative Williams, do you have a question?
Thank you, Mr. Chairman.
This will be the last one.
Thank you, Senator.
Yes, sir.
I've got a question kind of tied into 2. I haven't gotten it straight. I just need it straightened for me. I'm trying to figure out still how we can 11 straight years be ranked number 1 to do business in and a hellhole state for insurance. It's kind of an oxymoron. That's the first part. The second part is, everywhere I've researched, the top 7 states that are referred to as hellhole states, Georgia is never mentioned. Can you tell me, how do you reach this information, and where can I find? Because when I look at Search Magazine, what big companies are looking for, the 10th is tort. And after 25 years in economic development, I've never had a company deny me in Georgia because of tort. Straighten this out for me, please.
Sure. Thank you. Great question. As to the last comment that you made, and you've been in the business of economic development more so than me. I have done it a small amount in a few very limited roles. And I would tell you, with increasing frequency and with increasing severity, companies are talking about the problem with the civil tort system in Georgia and being a reason that Georgia is not as attractive or something of concern. But let's further look at it. That's going to depend upon what kind of business, right? Because some businesses are going to be more subject to or potentially victimized, if you will, by our tort system. Some would remain largely untouched by that. So I would say that for number one. Number two, the two metrics we're talking about are different in that those metrics, as I understand, those markers to determine how one gets to be number one state in which to do business, are not the same metrics and markers as used to determine how or where one is on the ranking of 50 states of the judicial hellhole list. So we're talking about not entirely different metrics, but they're not the same. So that's how they can exist at the same time. And with regard to the publication, I'll be happy, sir, to get that looked up. I think it's the American Tort Reform Association, I think is the entity or the publication. Sure. Yeah.
That's like Santa Claus like in Christmas.
Well,
Come on.
well, that would be the case, but the problem is if we had 50 Santa Clauses, that might make sense. But the problem is there's no reason to believe that they're going to want to ding Georgia more than any of the other states. So it's not saying, they're not independently saying y'all have got it bad in Georgia. They're saying y'all have it the worst of the 50 states. And that's why at the top of my comments, I made the point that regardless of what the metrics used for that, we're the worst of the 50. And so that's the wake-up call. Last thing I'll say to answer the question is, to your point, I fully agree with you. Even though the metrics are different for the two, I would agree with you that we can't remain at the top of those lists, both of those lists, for very long. We can't, because the two are so inconsistent with our ability to continue to track business if we do have that problem. But again, admittedly, it would depend upon exactly what kind of businesses that would be subject to the imbalance in the civil justice system.
Right.
Yes, sir.
All right, thank you. All right, thank you, everybody, and thank you, Senator Kennedy, for your time and effort, and I appreciate everybody with their attention to the issue, and I know some of you wanted to follow up, and you denied my request, and I greatly appreciate that. I've got about 10 minutes to...
Thank you,
before
Mr.
I'm
Chairman, and thank you to members of the committee.
Thank you,
Yes,
Senator. So I have a sub that I've distributed to the members of the committee. What I'd like to do is go over it and just explain where it differs from the as-passed bill out of the Senate. And then I think Representative Evans has some amendments that we'll consider. And I actually have 3 little cleanup ones that I want to put, I will request the committee consider. So just going through the sub, it's LC 492355S. So if you want, this is basically Senate bill. It's a 68, but it's got the following changes. So if you turn to page 3 on line 42, at the very top of the page there, the phrase "the issue of damages" has been inserted. And then the paragraph 2 there from lines 45 to 50 is new. That basically clarifies that while you cannot argue non-economic damages until closing, you can argue it in both when you have a closing, you have an opening and a concluding argument. So you can argue it in both of those as long as you argue it in the first, and your argument has to be consistent between the first and the second closing. Also, paragraph E, lines 55 through 58 were also added. And that is just saying that in voir dire, that's the portion of a lawsuit where you are questioning people who could be on the jury to determine whether they are, inclined one way or the other. You can ask them if they could return a defense verdict if the evidence demanded it, or if they could return a plaintiff's verdict in excess of some amount if the evidence supports it. So the idea is, I just had gotten some feedback from trial lawyers that that's a question you like to ask in voir dire to make sure someone's not predisposed one way or the other. And so we've tried to make it clear, as long as you don't throw out a specific amount, you can still ask that question. In section 2, there's some changes on page 5. At the top of the page in line 93, there right before, after the provided in this paragraph was stricken, that was stricken in the old bill too, the phrase "of the filing of such motion" appeared. So the 90 days ran from the filing of the motion. We're now just changing that to say it's 90 days from the conclusion of the briefing on the motion, so the court has a chance to at least consider the briefs. And we added a same change on lines 97 and 98. It's within 90 days following the conclusion of the briefing. We also added in lines 100 and 100 to 102 a phrase at the end of that sentence just saying that the remedy of the court to modify the stay doesn't preclude any other remedy available if the court does not timely rule on the motion, such as a writ of mandamus. So it's trying to make it clear that if the court doesn't rule, you're not limited just to asking the court again to modify the stay. The next change is on page 6 in line 121. That line did read the 60th day, so this is when you can voluntarily dismiss. It's staying at 60 days following the date the opposing party serves an answer, but it previously had read the 60th day following the date the opposing party serves either an answer or a motion for summary judgment, whichever occurs first. We've taken out the summary judgment, so that would not trigger that 60 days running. So it's just and then we replaced all that phrase with just an answer there. In section 4, there were no changes. In section 5, down at the bottom of page 7, lines 165 through 168, we added a phrase just to highlight the fact that the statute is being revised so that it is permissive. It is not mandatory. The statute, even as revised under Senate Bill 68, would not say that the evidence has to be admissible. It just can be admissible. If you notice on lines 161 and 164, the word "may" is used. That's not new. That was in the bill originally. So we added a phrase just to sort of make it clear that this paragraph, provided, however, this is lines 165 through 168, this paragraph shall not prevent a court from determining the admissibility of such evidence pursuant to Code Section 244403, that's sort of the balancing test, or any other statutory or common law rule of evidence. In other words, the court still is going to have to make a determination if the evidence is relevant in that particular case. In section 6, in page 8, on lines 184 and 185, we have tried to narrow the scope of the definition of negligent security so that it does not catch some other claims that people were concerned it might impact. And actually, I do have an additional amendment to propose to that as well, but we deleted "to keep persons or on or around any premises safe from wrongful conduct," just to say keep the premises in good repair and safe from the wrongful conduct of good persons. And actually, there's a concern that in good repair might unduly impact landlord-tenant, so I'm gonna request a motion to amend that part as well. Then on page 9 and lines 213, 214, we changed the definition of third person so that it would, it's basically defined as anybody except for the owner, occupier, or security contractor. We added to that anyone under the direction, control, or supervision of an owner or occupier or security contractor to make it clear that injury from someone that's an employee of the owner is not covered by this. This is where it's sort of a complete stranger. Then on page 10, we made a number of changes. On line 227, at the beginning of that line, right after the B, there was a clear and convincing evidence requirement that would have applied to all of the following 3 elements, the little Roman numeral 1, 2, and 3 from lines 229 down to 238. We've stricken clear and convincing evidence on line 227 and then clarified on 230 and 233 that when the owner occupier has to know, that is actual knowledge. So we've had actual knowledge. And then on lines 235, 236, and 237, there we did put the clear and convincing standard, so it would apply only to that third prong if the owner occupier knew or should have known by clear and convincing evidence. So it's just to the sort of imputed, not actual knowledge, but imputed knowledge. or constructive knowledge that the third person was or could be on the premises, and if the owner occupier had actual knowledge, it said knew previously there, so we just made it clear that's an actual knowledge requirement. Then on page 12, in lines 276, 277, after the code section reference, that's the civil cause of action for trafficking. The concern was if you just reference that code section, you're not including some of the other ways in which those claims are brought. And so we added, or any other applicable law or theory of recovery otherwise recognized by law, including but not limited to negligence and nuisance, to make it clear that any kind of claim involving human trafficking is not limited or impacted by the statute or by the bill. And then I think our next change is in section 8. So this is the bifurcation section. We tried to clarify on lines 420, I'm on to page 18 now, lines 423, 424, that if you have a right to bifurcate, and after the first trial on they determine that the defendant is liable, then we move into the compensatory damage phase, and we just added the words immediately with the same judge and jury to make it clear that you don't take a recess for 2 months and come back and try to retry the case. It's supposed to all just proceed one right after the other. And we did the same thing with respect to the punitive phase on 428 and 429. We added immediately with the same judge and jury. And then 434 to 441, we added basically an exception, 2 exceptions. If someone files the election, the court can reject it or overrule it if the other party files a motion to request that the case not be bifurcated based on one of these causes here. And the first one is the subparagraph 1 begins on 437. The plaintiff, or if the plaintiff is the legal guardian of a minor, the minor was injured by an alleged sexual offense and would be likely to suffer serious psychological or emotional distress as a result of testifying more than once in a bifurcated proceeding. That was to address some of the concern that we heard from some of the witnesses. And then number 2 is kind of a small case exception if the amount of controversy is less than $150,000. So the idea there was just to provide in cases where there's not as much in controversy, you don't have to do bifurcation. And so those are the changes on the substitute. Now, I'm sorry? Okay. So what I would like to do, I want to next consider the proposed amendments, but I'd like to, I think, properly put the substitute before the committee. So the chair will entertain a motion to pass Senate Bill 68 by substitute LC 49-2355S. All right, we have a motion, we have a second. All right. Now, Representative, I believe you got an amendment that you've distributed to us that you would like the committee to consider.
I do, and before I present it, which I appreciate, Mr. Chairman, you calling on me, I do have 3 specific questions about your sub, and also given that you have forecasted that you have a couple of amendments to it that could impact my amendments. If we're following Robert's rules to a T, we are only allowed to amend each section once, and I put all my amendments into one at your request for speed, and I just want to make sure that none of, if we consider smaller amendments to your sub, that just some assurance that my amendments will not be called out of order.
No, I don't intend to call yours out of order. I intend to vote them. My amendments, if the committee would like, I can go ahead and describe what mine are. I don't think it's appropriate to, I was going to let you go first with your amendments before I put mine, but if you would like to know what mine are, I'm glad to describe them to you.
Well, up to you. I'll do however you want to. I just wanted to make sure that my ability to move an amendment was preserved.
Well, why don't you go ahead with your amendment?
Okay. Thank you, Mr. Chairman. The amendment was passed out to all of you when you got here, and it's, again, at the request of the chairman, I put these all into one, and a lot of them are self-explanatory, and I'm going to try to be as brief as I can because I know that the hour is late. But section 1 on anchoring simply seeks to clarify that advocates will still have the ability to argue non-economic damages. There's some confusion on my part in the current sub with the use of the word unspecified in voir dire, only allowing the attorney to talk about whether a juror has any bias issue with issuing damages above an unspecified amount. That doesn't seem to help the ability to argue. My amendment would take care of that problem. The amendment would also ensure that for a plaintiff who doesn't work outside of the home, like a stay-at-home mother, that the value of that person's life could still be argued to the jury, where I believe under the current sub it could not. Section 2 seeks to address the unlimited stay issue. We heard testimony, and I will agree with Senator Kennedy on the fact that a motion to dismiss lingering for 6 years is certainly an outlier, but a motion lingering 1 to 3 years is not and is typical. And I'm really worried about the ability of evidence to be preserved, for memories not to fade, and for plaintiffs not to languish while they can't get their case moving to get the care that they need, and that good claims will die on the vine simply because of time. And so the amendment in Section 2 would lift the stay after 120 days. So you got 90 days under which we're saying by law, and have said for a while, that judges should act. After 120 days, the stay lifts, but certainly the defendant could move to keep it on if they wanted to. Section 3 addresses voluntary dismissals. Under the sub, a party would only have 60 days after the start of discovery, so 60 days after the answer, to make a decision about whether they wanted to voluntarily dismiss their claim. Let's say they learned something in discovery, they want to save everybody time and money and move on. 60 days is just, in reality, is just not enough time. Discovery opens, you send interrogatories, fancy word for questions for the non-lawyers. You get the party gets 30 days to answer. Typically, the defendant will ask for an extension. So let's just assume, though, that you don't. You got 30 days to get your answers. You get your answers. Usually, the documents that support any answers will come sometime on a rolling basis after that. You're certainly not going to have them in 30 days. Then that doesn't even give you the fact of being able to have anybody under deposition. So 60 days into discovery is nothing. And the amendment in Section 3 just says that the dismissal can happen anytime before the pretrial order is entered. So it still wouldn't allow you to go up and dismiss at trial, which would address the issue that we heard, Section 4 has a small change on attorney's fees. The amendment does to say that the fee agreement can be offered as proof, but is not conclusive, just leaving some discretion there for fact finders. Section 5 addresses seat belts, and I appreciate the work on the amendment in the sub from the chair, but this tightens up a little bit more and makes sure that we're only letting seat belts come in when it's relevant to the cause of the accident, and also just making sure that we're not an outlier here, Mr. Chairman. There's only 3 states in the whole country that allow anything near what is being proposed in the sub, and that's California, West Virginia, and Louisiana. So that's what Section 5 does. The amendment in Section 6 seeks to address the negligent security case. I want to talk about a couple of points here, some of which Chair Lady Miller brought to life in questioning with Senator Kennedy. Right now, you could have you could meet the standard under the sub. You could meet the standard of foreseeability that knife fights might break out, that there would be gunfire, that there may be rape, and still not have a claim because the rape, the gunfire, the knife fight didn't have anything to do with a defect in a physical condition. No broken gate, no busted out lights. The amendment would make it so that you have that expectation, and the business owners know what they need to do, so that foreseeability has those guardrails that the Supreme Court seemed to suggest and that witnesses have asked us for. But you don't cut out a class of claims just because there's no defect in a physical condition. So that's part of what Amendment 6 does too. I also want to note here, I appreciate what the sub does in attempting to make an exception for victims of sex trafficking and making sure that their claims remain. the amendment proposed in the package would certainly make sure that is true, because you wouldn't be tied to this physical defect issue anymore. And it's important that we have the amendment, particularly in Section 6, Mr. Chairman, because despite what I am sure are great intentions in adding the language related to sex trafficking victims, it is not going to help. And I want to be very specific here. And if the members want to look at the sub with me quickly. I was looking at the track changes because it's easier, but now I need to get my line numbers.
On the sub, you would be talking about lines 275, 277.
Yep, that's right. Thank you, Mr. Chairman. So members of the committee can see on line 275 and 279, the sub is attempting to limit application to two areas. Starting on line 275, limiting application to sex trafficking cases. On 279, attempting to limit or exclude contract cases. The languages and how those two categories of causes of action are excluded are very different, and it's very concerning. And again, I don't no dispersions here, but when you say nothing in this code section shall limit the ability of a claimant to make a claim in nuisance, trespass relating to in negligence or nuisance related to a sex trafficking case, that just means don't limit it more than you limit anyone else. And a judge applying that is going to apply this new law if we pass the sub in 68, and it's not going to apply it any different. It's not going to limit sex traffickers any more than it's going to limit anybody else. And so that doesn't actually help the victims. On line 279, you can see if you were actually trying to carve them out, you would do something, you would have to do the same language that you have for carving out the contract claims, that you will not, that this article shall not be construed to limit or otherwise affect a claim. And if the intent is to carve out the sex trafficking victims, then you would need to use the same language that you use for the breach of contract claim. So the amendment that I'm proposing would ensure that that's not an issue. The other reason that the amendment that I'm proposing is important, and I want to be clear, this was a team effort putting these amendments together. We combined them, but I'm moving them. The other reason that it's important is while I also appreciate carving out sex trafficking victims, I have a hard time looking at the mother of a rape victim who was raped in a stairwell. I have a really hard time looking at the mother of a child who may have been, their apartment may have been broken into, and that little girl was raped in her bed. She's not a sex trafficking victim. The girl in the stairwell is not a sex trafficking victim, but they are no less a victim. And how do I look those mothers in the eye? How do we, as members of the subcommittee in this august body, look them in the eye and say, we value one more than the other? So my amendment ensures that we're treating all victims equally, and that's another reason why I believe it's important, Mr. Chairman. Section 7 seeks to address the unfairness that some of us believe occurs because of Section 7, and that's the collateral source rule. This amendment would just ensure that you're going to put the full bill in issue, and if someone paid that for you, you might be able to take that off, but if it was paid for because of a contract that you paid to get the value of, then you don't take it off. The other reason that I believe the amendment in Section 7 is important, and this was brought out during one of the hearings, let's forget past medical bills for a second. Trying to apply a collateral source to estimate the damages that a plaintiff who has insurance might have for future medicals is just too many hypotheticals to make it realistic in real life. If you're going to take off the value of insurance, you're assuming that insurance is going to cover it. You're assuming that insurance is going to cover it at the same rate. You're assuming that this person is going to be able to keep their insurance. It's just too many assumptions, and so that's another reason why the language that we are proposing in Section 7 of the amendments is important. Section 8 on bifurcation is again an issue of fairness and efficiency. Let's don't bring victims twice. Let's also don't create confusion in how you can prove liability in phase 1 when, to nerd out on a law school hypothetical for a minute. You can't get liability unless you have a tort. You can't get a tort unless you have damages. So if we can't talk about damages until phase 2, that's a problem. I appreciate the attempt to, again, carve out something for sex trafficking victims on bifurcation in Section 8, but again, I would ask, why just them? Why the mother of a sex trafficking victim, not the victim, or not the family of a victim of rape or some other sexual assault? And why not the mother of a son who's been murdered? Why are we okay with asking her to come back twice? I also think that the $150,000 limit there is just not going to help a lot of victims, and also is not going to help the efficiency of the court. And with all appreciation or respect to the state that was mentioned that does that, it's the only one I've ever heard of. And again, I think the amendment in Section 8 is important for efficiency and fairness. Section 9 is just related to the effective date. The way that the current sub is written is that, other than Section 6 and 7, this bill is going to go into effect immediately. It specifically says, the current sub says, it's the intention of the General Assembly that all provisions of this act, other than the 6 and 7, shall apply to causes of action pending as of the effective date. So effectively, you could have a case in the middle of discovery, but with a motion to dismiss pending. What happens? You just halt? You're going to upend and cause inefficiencies in something that's already moving. What if you've got a trial started that's not bifurcated? What happens? What if you've got a jury out that has heard non-economic anchoring? It's not, and it's also not been the practice of this body since I think this would be my 12th session. We always try not to put our hand in pending litigation. And this does that more than any bill I've ever seen in my life. And so the proposed amendment in Section 9 is simply to say that the bill goes into effect upon signature or upon becoming law without signature of the governor, but it does not apply to any cause of action that hasn't yet accrued it doesn't apply to cases where the cause of action had already accrued. And that's just simply for the sanity of the court system, I think, and the litigants that are going to be in the middle of a lot of cases. The last thing I'll say, Mr. Chairman, is, again, I put these in a package at your request, and was happy to do it for efficiency. I do believe, I would like to think that there's interest in all these amendments in some way, perhaps by others on this committee, but I think particularly with respect to Section 2 and maybe even more so with Section 9, there could be interest. And so I would just say, if there is such interest, I would implore, beg, encourage my colleagues with an R by their name to perhaps introduce those separately, and then I would be glad to remove those from my omnibus package that otherwise I move to you now, Mr. Chairman.
All right. Thank you, Representative Evans, and thank you for consolidating that. We're over on time. That's sort of becoming my reputation, I think. So I appreciate you doing that so we can serve a little time. The lady has moved those amendments to LC 492355S, basically the amendments set forth in the paper that we've distributed to the members. I hear a motion to amend in that manner. Do I hear a second? I hear a second. All right, let's take a vote. All those in favor of amending LC 492355S, say aye. Well, let's raise your hand. And you can say aye at the same time too if you want to. Aye. Okay. All right, and then all those opposed, no, raise your hand. 1, 2, 3. All right, did you cipher those quickly? 7-4. Okay, so the motion to amend fails. Now I would like to I would like to propose some amendments. I don't think I can move, but there are 3 amendments, and I asked Representative Evans to do her amendments in one motion, so I'm going to do the same. On line 179 of this sub, there is a phrase at the end there that was left over from an earlier draft, and it was just brought to my attention. So on line 179, after the word means, the comma through the end of that line, except as provided in subparagraph B of this paragraph, comma, would be deleted because subsection B is no longer an exception. Additionally, on the same page, on line 184, toward the end of the line where the words "in good repair and" appear, we would replace that with "and approaches." The idea is to remove the good repair reference to try to make it clear we're not trying to impact anything of landlord-tenant law. So that line would be arises from an alleged failure to keep the premises and approaches safe from the wrongful conduct of third persons. And then finally, on line 275, Representative Evans, you got to me on that one. After the word limit, we would insert "or otherwise affect," so that that clause would have a similar sort of intro to the one that follows it. So the line 275 would read, "Nothing in this article should be construed to limit or otherwise affect," with an A, "any cause of action brought pursuant." So is there any questions about those amendments?
I do have one, Mr. Chairman.
Sure.
What is the rationale for treating victims of sex trafficking differently than other crime victims, including other crime victims of sexual crimes?
Well, I think it's just because of the primacy we place upon sort of the uniqueness of their plight. So I think we're just trying to, frankly, I'm just trying to listen to the overwhelming testimony we heard, trying to be responsive. I did try to listen, and that's part of the reason for that change. Now, in defense, the Senate already had the exception in there, but I heard some practitioners say, well, the way it's worded, it needs to be a little broader, and so we've tried to make it broader to address their concern. Chairman Newton. No, Newton, I'm sorry. He had
sorry.
tagged me before your light came on.
Sorry. Two things I do think, just in response to the lady's comment about, I do believe there's signs posted in almost every medical facility regarding sex trafficking. I do think it's gotten, as you say, some special attention by this body because of its growth and its importance. Secondly, on line 438 of the sub, it kind of takes another point at which there was some concern, which was other sexual offenses. This regards bifurcation, but the recognition that testifying twice in those particular situations with minors or with sexual offense, whether sex trafficking or not, I believe this line 438 would include any sexual offense, not just sex trafficking. Is that correct?
Yes.
Thank you, sir.
All right, Representative Miller.
Thank you, Mr. Chairman. Really quickly, I'm just going to address one point, and that is what my colleague, Chairman Newton, just addressed, and that's line 438. To echo my colleague, Representative Evans's point, I do think the intent here is very good, and I do appreciate this carve-out. I would just suggest that perhaps we strike by an alleged sexual offense and just leave it for any injured plaintiff. And here's why. There are cases, for example, a case in my experience where there was an awful car accident where an impaired driver caused a multi-death crash to include several young children. In the back seat of one of the surviving plaintiffs was her child, who was severed in half by a seatbelt. There are other cases that involve horrific tragedies and awful cases of victimization, I think, where requiring a plaintiff to testify over and over again, the juice is simply not worth the squeeze. I think if we could just carve out any victim who would be likely to suffer serious psychological or emotional distress, and give the plaintiff or the victim the opportunity to show that this would be, I think this would be a tighter and I think cleaner and more justifiable way to really get at what this section is trying to get at, and that is not re-traumatizing victims who have suffered greatly, who are innocent through no fault of their own.
Respond. So I'm inclined not to allow that amendment because I would like to have a vote on the other amendment that I've solicited first, and I'm concerned that doing that would expand that exception to the point where it could swallow the rule. So I'd like to go ahead and request a motion on the amendments that I proposed as one amendment. Those are the three things to line 179, 184, and 275 first. I have a motion. Do I have a second? All right, so we've got a motion to make that the three amendments that I described earlier, and a second. I'll go ahead and just call the question. All those in favor of that amendment signify by saying aye. Aye. All those opposed, no. All right, so that amendment carries. All right, so now we have the substitute LC 492355S as amended. I think we've got the amendment effective. I've had a motion and a second, so I will now call the question on recommending to the full committee that a do pass recommendation for LC 492355S as amended. Is that the correct phrasing of the motion? Right, so, yeah, right, gotcha. So we'll have to get a new LC generated for the Rules Committee meeting, but for our purposes now, I think that's the proper phrasing of the motion. So have I had a motion second? Okay, so I got the motion and the second. All those in favor signify by saying aye. Aye. All those opposed, no. No. All right, why don't we raise hands so I can count. All in favor. And those opposed? The ayes have it. All right, so the motion passes. All right, I think that concludes our business for today. I'm turning the room over to Chairman Parrish about 20 minutes late, so thank you everybody for your attention.